Ripple has scored yet another win against the SEC. What happened this time and what consequences will it have for the case? Could this mark the end of all hopes for the SEC? Stay tuned till the end of the video to find out. But first, we are giving away 25 XRP at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comments section. Welcome back XRP Army. According to recent information that was provided by Ripple's defense attorney James K. Phelan, Ripple has been awarded another victory in the ongoing lawsuit after the court denied the SEC's request to seal in its entirety its opposition to the amicus request to participate in the Daubert challenge. This was done after the court denied the SEC's request to seal in its entirety its opposition to the amicus request to participate in the Daubert challenge. This triumph follows the court's denial of the SEC's motion to seal entirely its opposition to the amicus plea to participate in the Daubert proceeding. According to a tweet that was posted by Phelan, Torres has declined the SEC's request to seal the case as part of its objections to the filing of a brief by 6 Ripple investors regarding the determination made by one of the Commission's experts, Patrick Doty. This request to seal the case was made as part of the SEC's objections to the filing of a brief by 6 Ripple investors regarding the determination made by one of the Commission's experts, Patrick Doty. The complaints were presented as part of the SEC's response to the brief that was submitted by the investors in Ripple. The court refuses SEC's motion to seal and orders it to file by June 14 a redacted version of the brief and exhibits under seal, redacting information only to the extent necessary to protect information sought to be filed under seal, tweeted Phelan. Ripple and the individual defendants all took a stance against the conditions that the SEC had imposed in order to maintain the confidentiality of the documents. Because the plaintiff now claims that the notes and emails are safeguarded by attorney-client privilege, after being denied the deliberative process privilege. Do you agree that this is great for Ripple? If yes, then make sure to like this video. Judge Netburn was required to disclose SEC's various and contradictory viewpoints on the speech. The plaintiff's new argument comes after the denial of the deliberative process privilege. According to the report, the judge has also issued an order mandating that the regulatory body provide an explanation for the proposed redactions and a list of the exhibits that it intends to keep confidential by the 14th of June. The order also requires that the regulatory body provide a list of the exhibits that it intends to keep confidential. Ripple asserts that out of the 5 reasons cited by the SEC in its request letter, 4 of them do not constitute a risk to human life. The Securities and Exchange Commission cited concerns for the general populace's safety as the basis for its decision to keep secret its rejection to a request from amici to participate in Patrick Doty's expert challenge. On the other hand, the blockchain startup and others who supported it promptly responded to the claims made by the SEC and demonstrated that they were false. BTW, do you think this will be the end for the SEC? Let us know in the comment section down below. Additionally, Jeremy Hogan has shared their thoughts on this topic with us. Jeremy Hogan, a legal specialist on cryptocurrencies, believes that the United States Securities and Exchange Commission, SEC, is acting in error in its case against Ripple regarding XRP. Recent disagreements in the case have centered on documents connected to William Hinman, a former director of the Securities and Exchange Commission. In 2018, Mr. Hinman delivered a well-known lecture in which he stated that Ethereum did not qualify as a security. The most recent disagreements in the legal proceeding all revolve around these documents. The United States District Court Judge Sarah Netburn issued an order in January compelling the Securities and Exchange Commission, SEC, to release emails relating to the speech. Despite the fact that the SEC opposed the judgment, the order was given by the judge. In spite of the fact that Netburn did not accept the challenge and instead told the SEC to deliver all of the necessary drafts and emails in April, she did give the explanation that was requested of her. After that, the SEC issued a request for further time in order to lodge an objection against Netburn's decision to overlook their challenge. This was done in an attempt to stop Netburn from ignoring their claim. According to Hogan, the concerns voiced by the SEC were the primary topic of discussion during the hearing that took place on Wednesday. The attorney says that the Securities and Exchange Commission, SEC, has made a mistake since it has argued about the Hinman emails using a variety of strategies, and that this is the reason for the SEC's error. But there was a big mistake made by the SEC in this hearing. Remember last year we talked about a theory of a case and why it's so important to stick with your theory in litigation. And then we talked about how it was a mistake for the SEC to change its argument on what Hinman's speech was. If it was going to make the gambit that it was Hinman's personal opinion, you have to stick with that, and here's why. Now we know Judge Netburn has already ruled that, at least for discovery purposes, Hinman's speech was his personal opinion. So the SEC can now argue it's not relevant to anything, and that's fine, but we know that now hurts the SEC in those discovery motions, so there was a trade-off there. But the SEC attorney was trying really hard today in arguing various positions in order to try to win this motion, which was probably not really possible to even win. The judge asked, "Is the SEC taking the position now that the speech reflected the Division of Corporate Finance's position?" And the SEC attorney said yes. Now she tried to equivocate a little bit after that, but the first and the direct answer was yes. Comment XRP Army if you believe Hogan is right. According to Hogan's report, a counsel for the SEC indicated that the purpose of the speech was to offer information to the market about how the SEC would view digital assets. These two statements, in Hogan's opinion, put the Hinman speech back into play as market guidance and puts it back into relevance, which may result in the speech coming back to haunt the SEC. Two different correspondents for Fox News, Eleanor Tourette and Charles Gasparino, both have the same point of view on this as Hogan. They assert that the speech that was delivered by William Bill Hinman, a former official at the Securities and Exchange Commission, 4 years ago could be the factor that decides the outcome of the Ripple litigation. On Tuesday, the release of the Hinman records was the topic of discussion at an in-person conference call that was hosted by a federal judge named Sarah Netburn. Ripple asserts that the documents are necessary in order to prove that it done nothing wrong and that the SEC is picking winners and losers in the fledgling cryptocurrency market. The release of the Hinman documents was the topic of discussion during the conference call that was held. Officials from Ripple believe that the records that the SEC is trying to keep hidden will demonstrate that there is disagreement among the agency's senior officials over the designation of XRP as a security, which will undermine the position of the SEC. The SEC is trying to keep the records hidden by saying that they will demonstrate that there is disagreement among the agency's senior officials over the designation of XRP as a security. During the course of the conference call, participants brought up a number of topics for John Deaton, the founder of Crypto Law, to discuss. The series of tweets indicates that Judge Netburn kicked off the conference call by reminding both sides of the reason for holding the hearing. After that, he persisted in his demand that the SEC provide more information regarding the nature of the legal counsel that was provided to former Director William Hinman and the context in which it was provided to him. Following this, the organization provided a response, stating that Hinman got legal guidance from SEC attorneys on the application of securities laws to digital assets in order to prepare for his lecture, and remarking that that speech was very legal. After confirming that she had heard the words correctly, Judge Netburn continued by asking, so he wasn't asking for legal advice to educate himself on legal standards, but to be sure he wasn't inconsistent? So he was looking for legal advice to make sure he wasn't inconsistent. The reaction from the SEC was positive, thus the question can be answered yes. What do you think about Ripple's new win? Is it over for the SEC? Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.